Welcome to the second panel of the webinar on judicial lawmaking in European constitutional courts. This panel will be devoted to the judicial lawmaking in Western Europe, but also the impact of the judicial lawmaking in Western Europe on East European constitutional courts. And I'm very pleased to introduce the chair of this panel, Professor Jan Komarek, from the Center for Excellence of International Courts, University of Copenhagen. So thank you, Jan, for joining us, and please take the screen for chairing.
All right, so am I now permitted to start? Okay, so thank you also for inviting me to this conference. And I think without further ado, because there is lots of great papers based on the book which has been already published, so I hope that there is also going to be a rich discussion. And let's start with the first paper by Ruth Weber, who is a postdoctoral researcher at the Humboldt University, and her contribution is on the German Federal Constitutional Court. Before you start, just one thing, you all have 15 minutes. So please keep to the time limit so that we have enough time for the discussion. So Ruth, please, the floor is yours.
Thank you for the introduction, and also especially thank you to you, Monika, for organizing this webinar. I will share my screen with you because I prepared a presentation. And yes, I'm happy to speak to you today as I really enjoyed working with you on the book project, and I will shortly present some of the results I found in my chapter. So I'd like to start with a virtual tour of the German Federal Constitutional Court, and I will try to enter its website to give you a short impression of the court. So the court was created by the Basic Law in 1949 and took up its work in 1951. It has been located in Karlsruhe, a town in southern Germany ever since, and this town is called the residence of the law. So I hope you can all see the screen now. You can see the front plaza of the court here, and just in front of you, you see the main building, the courtroom building of the Federal Constitutional Court. And if we turn to the right, you see the building where the judges have their offices, and yes, also the entrance for the judges just in front of us. So maybe, as you can already see, the architect used a lot of glass and steel because his idea was to represent transparency and communication, two main interests of the image of the court. And if we now enter the courtroom building, we can have a closer look at the courtroom itself. You can see the 8 seats for the judges just in front, and also the Federal Eagle above them, and a lot of seats for the general public, journalists, and the parties who take place just in front. So in general, the court is highly accepted by society and enjoys great trust. In the Federal Republic, going to Karlsruhe is shorthand for the enforceability of each individual's fundamental rights vis-à-vis the state. But why does the court have this reputation? This question is linked to its lawmaking activity. I will try to answer it mainly by looking at some important example of its case law. So I will now re-enter my presentation and start it. Where can I start? So I will describe 4 stages of the lawmaking activity of the Federal Constitutional Court, and the first one will be its early self-definitions in the 1950s, which took some emancipatory decisions. Then I will look at the complex issue of political neutrality. And thirdly, I will concentrate on the creation of new fundamental rights, which you could describe as constitutional lawmaking. And finally, I will have a short look on the influence on sub-constitutional law, which are, for example, instructions to the legislature. So you might already have heard of several important decisions that the Federal Constitutional Court took already in its early years and that defined what it is now. I won't be able to talk about all of these decisions. That is why I will pick probably its most important one. It's the Lewd decision, which the court decided in 1958. You can see the front page of its file stored at the Federal Archive in the slide. So the Lewd decision is probably the most important decision of the court, as I already said. And what happened in this, or what did the court decide in this decision? According to it, the basic law represents an objective order of values and fundamental rights permeate to all areas of law. So with this decision, the Federal Constitutional Court had also to deal with Germany's Nazi past. The lawsuit had its origins in a call for boycotts pronounced by Hamburg Senate Director Erich Lüth. With his call for boycotts, Erich Lüth objected to a film by a director who had made his career in Nazi Germany. It was called Feithalan. As the Federal Constitutional Court understood the basic law as a set of values and the freedom of expression as one of its central components, it came to the conclusion that the prohibition of the call for boycotts was not compatible with the basic law. Fundamental rights thus also have an impact on private law, which means that individuals are indirectly bound by fundamental rights. The fundamental rights were thus granted a far-reaching effect, and the legal order was constitutionalized as a whole. The constitutional judges themselves consider the Lüth decision, together with other early decisions, to be milestones of the 50s, as they had a large effect on the meaning and establishment of their constitutional jurisdiction. This demonstrates that in the early years of the courts, its own activism led to its outstanding position in the Federal Republic. I will come to my second point and talk about the complex issue of political neutrality. So we have seen that the Federal Constitutional Court had gained increasing authority in its early years and was considered to be largely free from political influence. After several conservative governments and grand coalition in the 1960s, the Social Democratic Party won the government majority for the first time in 1969 and formed a coalition with the Liberal Democratic Party. From this moment onwards, the Federal Constitutional Court, with a majority of judges aligned with the Christian Democratic Party, ruled against several legislative projects introduced by the Social Democrats and the Liberals. One of the most famous examples is a decision of 1975. In this year, the court took a decision on abortion, and you can see a picture of the oral hearing on the slide. Following a change in law, punishment was precluded for abortion within the first 3 months of pregnancy. The court declared that this exemption from punishment was unconstitutional because it violated the protection of life. This decision, amongst others, was heavily criticized, and the Federal Constitutional Court was accused of having decided based on party lines. In the following years, critics repeatedly accused the court of not being politically neutral. Such criticism came at different times from different political camps. Current decisions in the context of politically controversial questions show that it can certainly be seen as an important actor in society's development. different decisions clearly show that the Federal Constitutional Court, in its function as guardian of the Constitution, is not an apolitical court. This already became clear in the early decisions of the court in the 1950s, the implications of which are still relevant today. Both then and now, the court has positioned itself between the judiciary as a Supreme Court and as the controller of the legislature, as a constitutional body whose status is derived directly from the basic law and which necessarily acts politically. So my third slide is on the creation of new fundamental rights. We have seen that the Constitutional Court has a very important role, and this role remains unchanged to this day. As I already said, the court has a very high reputation within German society, and this is largely due to the possibility of being able to make individual constitutional complaints. Although this requires subjective infringement of a fundamental right, this remedy promotes the constitutionalization of the objective legal order as a whole. The function of an individual petition by means of a constitutional complaint is not only to protect individual rights, but also to uphold the objective constitutional order. The citizens is thereby mobilized as the constitutional centerpiece for the enforcement of fundamental rights. Already in the 50s, the court decided that the general freedom of action, according to Article 2, paragraph 1 of the Basic Law, serves as a catch-all fundamental right. Through this broad understanding of the scope of protection of the general freedom of action, the Federal Constitutional Court furthers the influence of constitutional law on the entire legal system. In addition, the court has combined different fundamental rights or defined the scope of certain fundamental rights in various places in such a way as to create new fundamental rights. This can be understood as constitutional lawmaking. So on the slide, you can see some examples for this phenomenon. So one example is the census decision that the court took in 1982 and where it created the right to informational self-determination. A second example is the decision on online search of 2008, where the court created the right to guarantee the confidentiality and the integrity of informational technology systems. And a third example is the Hartz-IV decision. Hartz-IV decision, it's the name of the law. And in this decision of 2010, the court created or named a law of a right of guarantee to minimum subsistence level. So these are examples for the constitutional lawmaking. I will now turn to my fourth and final point as to sub-constitutional lawmaking activity of the court, and this is linked to the court's ability to declare the invalidity of a law with binding effect erga omnes. In the event of a declaration of invalidity, the Federal Constitutional Court has adopted detailed transitional provision in a number of decisions. These are particularly prominent examples of the lawmaking activity of the court. So I will now end my presentation with one last example of the case law of the court, and this is the decision on the Slm Seekers Benefits Act that the court took in 2012. And in this decision, the court annulled the amount of cash benefits under this law. The previous cash benefits were based on flat rates that had not been harmonized since 1993. Therefore, the court considered a transitional arrangement to be necessary. And the reasons for the decision, it comprehensively explains why precise transitional arrangements are needed. Accordingly, a further application of the unconstitutional provisions was not acceptable because of the existential significance of basic benefits. the fundamental vital needs of the beneficiaries were to be met at the time when they arose. Moreover, the court stated that it could not foresee the legislature introducing a new regulation, despite an announcement to the contrary. In the court's eyes, there was an inevitable need for uniform, abstract, and general provision on the amount of cash benefits. The court also explains the consideration that led to the concrete transitional arrangement and emphasizes, I now cite the court and the reasoning of this decision. This transitional arrangement does not replace the decision of the legislature. The latter has a constitutional duty to take a decision of its own, consistent with the requirements of the basic law as to how and by which amount the minimum existence of the group of individuals affected by the provisions declared unconstitutional may be guaranteed in the future. This shows that the wording of the decision clearly seeks to give the legislature considerable leeway, which is, however, limited in practice by the concrete proposal of a transitional arrangement. The example illustrates that even in decisions these and other examples show that in decisions originating from completely different fields of law, the Federal Constitutional Court submits detailed proposals for the correction of unconstitutionality to the legislature. So I'm now coming to the end of my presentation. I will just show you the 4 stages I just explained. We have seen that firstly, already in its early years, the Federal Constitutional Court took emancipatory decisions. Secondly, political neutrality is and remains a complex issue. And thirdly, the court contributes to constitutional lawmaking by creating new fundamental rights. And finally, has a strong influence on sub-constitutional law, for example, by giving instructions to the legislature. So thanks for your attention, and I'm happy to discuss further aspects later.
All right, thank you very much. So as I tried to announce, because I forgot to say at the very beginning of our session that our audience is invited to put their questions into the chat, but as far as I can see, there is none. So I might have one question from me, but I do not want to suppress discussion, and we have at least 8 to 10 minutes if you want to be just to each of the speakers. So maybe I will start, and let's see if other questions will appear. And the question will relate to something which is not in your chapter, so it may be unfair, but also because you are educated in Germany, you may answer it and it may add to the perspective you've offered us. And that is a great part of any court's authority is how the court is being presented in legal education and how its decisions are being taught to students. And in my little understanding and knowledge of the German legal system, it seems to me, so as far as I know, that court decisions are rather presented as uncontested truths. Is that true? And to what extent it might be changing, and is there any influence from Anglo-American legal culture? I remember it's been a long time now ago when I read a book review by an American comparatist, James Matzneiner, who admirably was reviewing a book by Reinhold Zippelius on the juristic method. And he was saying part of the problem of the American legal system is that our students are taught to problematize everything. So they do not really pay any authority to court's decisions, whereas in Germany, and I mean, I do not agree with that, but I just wonder if there is still this element of uncontested authority of the German Constitutional Court among the teachers of German public law in Germany, or whether you can see any change. So that's one question. So if you may, you can start answering it, because there is one more in the chat, and I will try to.
That's a very interesting question, but and I only can answer it by my own experience during my studies, as I don't have any empirical data on how much contestation of the court decisions really happens during the law study. So, but I think it's probably it's true because, and it's probably but it depends also on the functionality of constitutional law so I think in panel or civil law lectures, the contestation of the court decisions of the highest courts are really much more prominent than in the constitutional law lectures, as the constitutional or the decision of the constitutional court are mainly the content of the constitutional law lectures. But it's not really, I think, probably if you study them, it's not really based on their text, but it's more, it's on their concrete, but it's more their concrete substance and not their argumentation. But on the other hand, as they, since 1971, there are dissenting opinions to the judgments of the constitutional courts. This is something that is explained in constitutional law lectures, and sometimes you can also read these dissenting words. But as the decisions are so long, it's probably also one factor that explains why it's probably more concentrated on the dogmatics of the constitutional law than the decisions themselves. Yeah.
Mm-hmm. And there is now a number of questions in the chat, but because we only have 5 minutes, I will take the liberty of trying to summarize them to you so that we do not devote too much time to different people. So I apologize to the audience that you only wrote your questions and I will now represent you. So one is on how the court is being presented in the public constitutional discourse, media, popular journals, and is constitutional adjudication scientific and objective in quotation marks, or is it just politics by different means, or is it something in between? And you said that court is both political and judicial. How the two are accommodated in practice? Are there frictions? So that's one, law and politics, basically, and how the court is being perceived. Is it still perceived as a legal institution or something, political? Relatedly, Gabor Halmai asked, how do you explain that there is almost no scholarly criticism of the pretty conservative abortion decision of the German Constitutional Court? Another question is, well, I suppose it's not a big problem in Germany, but still, is there any constitutional responsibility for non-enforcement of the decisions of the German Constitutional Court by public authorities? And is there any procedure of the correct implementation of the decisions prescribed by the law? So essentially what happens if public authorities decide not to respect a decision by the German Constitutional Court? And I would just add, has it ever happened in the German constitutional history? And the very first question, it says, the basic law provides specifically these possibilities of lawmaking, or based on which construe arrived to which stages? I'm afraid I possibly do not understand it completely, but hopefully there is enough material for you, and you have around 3 minutes to answer them. So
yeah, wonderful.
You can also pick and choose.
Wonderful and impossible to answer all these questions.
That's the best, right? You can avoid the difficult ones.
I think I just didn't get all the questions in such a short time, but I will try to answer some aspects. So I think the Constitutional Court is really very present in media as well. Maybe, and there are several press and television channels who have a little section only in Karlsruhe to observe the court, and it's also discussed how they communicate with each other, media and the court. So I think this is very present. I don't know if they are really critique a real critique of the media of the court, but that also exists. So just recently there was a discussion on when the press is informed of certain decisions of the court. So this is something that is discussed also right now. And on the scholarly discussion on the abortion decision of the 1970s, I think it was contested by a lot of scholars, or at least it isn't, maybe it wasn't at the times. So at least now it is. But as the court took a second decision in the 1990s, which I think it's, in general, it's a very difficult problem, and probably the solution the court find, I don't find it that convincing, but I'm not sure what the scholar said at the time. It's probably the general public was much more critical than legal scholars, but yeah, this observation is certainly true, this observation. So and I think the problematic objections to the decisions of the Federal Constitutional Court, it is discussed, and there I can also recommend one interesting, I think, habilitation that was written 1 or 2 years ago, but it's until now it remained a theoretical problem, because in general the decisions are, there is no objections to the decisions of the court. And so, for example, one question that arises is, could the legislature re-enter the same law as that had been declared unconstitutional, but it didn't happen until now. So yeah, but maybe it's interesting to know that that was also interesting in the earlier discussions, that the discussions on constitutionality of statutes is really very present in the discussion of law of when the statutes are produced in the Bundestag. So sometimes we could also be critical that the politics use the court for unpopular decisions on declaring some aspects of the law unconstitutional. Mm-hmm. So we can just, maybe we can go on to the next presentation and talk about further aspects later, because maybe they will come up in the other presentations again. Mm-hmm. So
all right, so let's move to another paper, and let's also see if we have some time at the end of the session. But the next presenter is Nausicaa Palazzo, the postdoctoral fellow at the Hebrew University of Jerusalem, and she will talk to us on the lawmaking power of the Constitutional Court of Italy. So Nausicaa, if you are there, because I have
yes, can you hear me okay?
Okay, so right. Let's get started then.
Okay, thank you very much. Thank you, Monika, for involving me in the project from the get-go. I've learned a lot from the other chapters and from your concluding chapter, and this research has actually triggered my interest in a related topic, which is whether US notions of judicial activism are a good fit for Europe. And this article has been published last week, so it kind of feels like I'm coming full circle on this topic. So I look at where the Italian Constitutional Court stands on the metric of power. And of course, the positioning of the court in Italy is not fixed, because it depends on factors such as the stability of the executive branch, the availability on the part of the judiciary to cooperate in bringing legislation in line with the Constitution. However, I have concluded back then that the court has used in a pretty intense way its power to issue its lawmaking function, and it has actively intervened in the face of persistent legislative inertia, which seems like the veritable constant of the Italian parliament throughout the year. Yeah, its inability to respond to social change promptly. And to reach this conclusion, I look at the tripartite distinction by former Constitutional Court Judge Zagrebelski, which distinguishes between legislative functions, non-legislative functions, and co-legislative functions. Of course, non-legislative functions are those whereby the courts act as a negative legislator, and there is empirical research suggesting that this function is less and less relevant. By contrast, its legislative function is becoming increasingly more important, also numerically. And this term refers to the Constitutional Court's legislative the Constitutional Court so-called self-executing decisions, sentenze legge, which do not require the cooperation of other institutional actors to, again, interpret and implement the Constitution. And this notion includes actually quite a lot of categories, such as interpretative judgments, whereby the court imposes actually on other ordinary court a certain meaning, especially by striking down meanings that it considers as non-compliant with the Constitution, and manipulative decisions. That is all the set of decisions whereby the Constitutional Court has actually actively manipulated the text of the law by deleting commas, small words, replacing words, adding new words in a quite an aggressive way sometimes, as it demonstrates the, for instance, the two decisions in the field of electoral laws, whereby the court has actually written the electoral law that's been used in the last election. I think that additive judgments are the most illustrative example of the willingness of the court to exercise a lawmaking function. And by additive judgment, I refer to all those judgments whereby the court declares the law unconstitutional to the extent that it lacks the word X. So to the extent that there's not a word which is supposed to be there because the Constitution commands that. They are significant because, of course, we have, of course, it's a problem, maybe not as much as in the United States. It's not dealt with such in an obsessive manner as in the United States, but we also, I've tried to strike a proper balance between self-restraint and activism. So the opportunity to intrude in the lawmaking sphere and to restrain. Starting from the beginning, the Italian Constitutional Court recognized that the legislature enjoys discretion when it comes to when there are rules that do not command any specific solution or mechanism for their implementation. And its earlier approach resembled that of the European Court of Human Rights, whereby the court would still police the use of discretion by parliament. Then the court became a bit more deferential toward parliament and started issuing decisions of inadmissibility, whereby it would not police the use of discretion by parliament. And then around the 70s, for the reasons that I will tell in a moment, the court will go back to policing again the use of discretion, and in a quite, and also making a decision itself through additive decisions, whereby the court, again, adds words based on the Vezio Crisafulli doctrine of the proscribed verse. So there is a direction that the Constitution commands, which is clearly identifiable, and therefore the court has an opportunity to remedy legislative omissions by adding itself parts to the law. So And ultimately, there is this peculiar co-legislative function whereby the court engages with varying degrees of intensity with the lawmaking process, either ex post or ex ante. Ex post would be when opponents of a certain law engage in strategic litigation. This is not very common in Italy, especially historically, it has not been very common. But because we have this idea, which I think is probably common in other continental European jurisdictions as well, that change must occur, must be brought through political avenues, not through the court. But this channel of, again, legal change is becoming more and more relevant, especially thanks to the Italian party called Partito Radicali. And I would especially like to mention the recent strategic litigation triggered by Marco Cappato, a leader of the Partito Radicale, who brought a famous DJ who was quadriplegic to Switzerland to commit assisted suicide, and then he surrendered himself to the police, and then the criminal trial started, and the Constitutional Court struck down the law prohibiting assisted suicide altogether. But again, this is still an exception to the rule whereby change occurs through political avenues. And then we have ex ante interventions of the court, whereby the court triggers a dialogue with parliament, especially through so-called exhortative decisions, whereby the court does not strike down the law, but still gives a warning to the legislature that if it does not act within a certain period of time, it will strike down the law. Yeah. Okay, so basically I have observed in my chapter a linear progression of the court towards an expansion of its powers, and especially in the 70s, because at the beginning, the role of the court was that of aligning the legal framework with all its laws coming from the fascist era with the newly introduced constitutional values. So this is the phase where the court especially engages in a dialogue with the ordinary courts, asking for help. Please help me align the legal framework with the constitution. And this is also the phase where the court acquires pretty a very significant institutional prestige and reputation that allows it at a later time in the 70s, more or less, to change interlocutor, namely to start redirecting attention to parliament. So starting from the 70s, the court has been more and more willing to again urge parliament on introducing new reforms, making reforms itself through manipulative decisions. And this is why many commentators speak of an increasing incidence of substitution, supplenza, which is the attitude of the court on, again, taking on the duty to align the law with the constitution in the face of the persistent failure of parliament to do so. And supplenza is also exemplified by an increasing willingness of the court to intrude into a very delicate social policy, areas of social policy, such as same-sex marriage, assisted reproduction, and therefore is exemplified by a kind of politicization of constitutional justice. I agree with Professor Rodotà, Stefano Rodotà, in a sense, because he actually argues that supplenza is not an appropriate term to describe what's going on in Italy, because it's he argues that it's illusory to think that one could put a break on this form of very strong activism, because the court is really unlikely to give up on this impressive set of arsenal of types of decisions, powers, maneuverability that it's been carving out for itself throughout the years. So he speaks of redistribution of powers within the constitutional framework, meaning that an irreversible redistribution of powers within the constitutional framework has occurred, in his opinion. So I will stop here and just leave you with this note. I know that it's very problematic from a theoretical perspective to say it out loud, especially in continental Europe, that courts exercise a lawmaking function. But I'm also, I was also glad that the court did that in specific times of our history, especially in recent times, where we had the bi-populist government that came to power and that tried to curb, for instance, the prerogatives of parliament. And that's where the Constitutional Court and also the President of the Republic, which is also the guardian of the Constitution, demonstrated that the two guardians of the Constitution are very much awake and vigilant. So I think I'm happy to know that, because Italy is going to go through stormy times. Especially now that the Prime Minister has stepped down, and there is a near certainty that we will have a right-wing government, probably far right-wing government, should there be election. So again, that's problematic from a theoretical perspective, but very, very reassuring. I'm looking forward to your question. Thank you.
Thank you very much also for respecting the time limit. And again, I would like to encourage everybody to put their questions into the chat. And it seems, again, I have to be the one who is taking advantage of being a chair. And one question I would have, again, it's not in the chapter you have written for the book, but I hope you will be able to reflect on it. And that is, I will now put my hat of EU constitutional scholar on, and would ask, because you mentioned that the lawmaking activity and also the authority of the Italian Constitutional Court started to increase in the 1970s. And that is also the period, and that applies also to the German Constitutional Court, where these courts started to put limits on the reach of European economic community law back that time in the national constitutional legal order. So do you think there is any relationship between the two, or were these decisions on European integration back in time rather marginal, and they became important only later in time when community law became ever more important?
Oh, can I answer right away?
Yes, we still have about 10 minutes for the discussion, and there is one more question in the chat. So okay, please go ahead.
Okay, thank you very much. I actually don't have an answer for that, but I think the question is really fascinating. And I think it was relevant back then, what was happening with the EU laws, because I think the Italian Constitutional Court was one of the first to raise the issue of counter limits. So it made me think actually that that might also have contributed to this image of the court as an extremely, prestigious actor that's able to stand up in the face of social challenges. So there might be a link. I would very much like to look further into that. Yeah.
Mm-hmm. And then there is a conceptual question by Max Tower, another participant, active participant to the workshop. Sorry, Max, again, I will read it for you. And that is, he's thanking for the presentation. And then the question is, can a court ever be activist when it exercises its powers in protecting democracy within a democratic regime context? Would it not be activist towards the constitution and the differential towards the executive or other actors aiming to undermine democracy if it gave up on that protection?
That is an extremely important question, and thank you, Max, for bringing up, because it's the question that I have addressed in this other article, where I conclude that activism is a known problem conceptually in Europe because of a host of reasons, including the form of government that it's in most countries, in most continental countries in Europe, is not US-like. So we have super partes constitutional courts external from the three branches of government. So it doesn't look like a struggle between equal branches. And then we have a host of theoretical, conceptual reasons, such as those that Max mentions, especially the fact that at some point, especially neo-constitutionalism as a legal philosophy, and I mentioned Ferraioli in my article, has contributed to shaping this idea that it is actually activist, if any, to not react in an US-style activist manner to situations that jeopardize the rule of law. So again, bringing it's really a different issue in Western European continental systems where, how to say, it's more, again, it's more probably a question of constitutional interpretation, but one would, but yeah, I would say that it's more important to be activists to protect the Constitution. Therefore, it's a non-activist way of proceeding. I don't know if I made myself clear. I got kind of lost in my thoughts. But yeah, I would definitely say that continental systems in Europe have contributed to this idea that we have to be activists to protect democracy, because that's not activism, and that's protecting the Constitution.
All right, so there seem to be no further questions at this point, but let's keep this space for us. We can use it also at the end of the workshop, if you agree, and if there is no other question appearing, as it is not, it seems. So for the moment, I would thank you, Nausicaa, and we just move to a third paper in this workshop, and this time it is on the Spanish Constitutional Court as a lawmaker. Now, I apologize because my Spanish is non-existent, so I might mispronounce the name, but as I read it, it's Covadonia Ferrer Martin de Vidales. Sorry again, and I hope you are with us, and you can start your presentation again.
Yes, thank you very much. Perfect pronunciation.
Thank you.
Okay, thank you very much. First of all, I would also like to thank Professor Monika Florczak for trusting me to participate in this book, and I'm really pleased to have been able to work with all these excellent colleagues from different countries of Europe. I'm going to share my presentation with you. Just give me a minute. Are you seeing it? Because I'm not seeing it in my screen, so I was not sure if you were able to see it. With my presentation today, I want to focus on the essential role that the Constitutional Court plays for the Spanish democratic state, and in particular on the creative role that the Constitutional Court performs through its interpretative judgment. Before starting, I just want to briefly remind that the Spanish Constitution opted for a model of concentrated constitutional justice with some elements of the diffuse model, and that the Constitutional Court is the body that guarantees the whole constitutional order and is completely separated from the judicial power. And this is explained because of previous past or experience during Franco's dictatorship. And as the supreme interpreter of the Spanish Constitution, its main function is to carry out the absolute control of the constitutionality of the law. In Spain, we have this debate in the doctrine between if the Constitutional Court is a positive or a negative legislator. Most of the doctrine understands that with this absolute control of the constitutionality, the court is acting as a negative legislator, not creating any new laws, but just declaring with erga effects with it's already implicitly contained in the Constitution. But other authors, on the contrary, understand that with this absolute control, the Constitutional Court is also participating in the legislative function and acting as a positive legislator. Well, if we take into account the current configuration and the practical development of the Spanish Constitutional Court, we can say that the Constitutional Court also carries out lawmaking activity through its interpretative function, as we have been also seeing with the cases of other Constitutional Court in that we have been explaining in today's webinar. And the Spanish Constitutional Court performs also a creative role through this interpretative function, and it can specify not only the content of the provisions of the Constitution, but also the content of other legal norms. It can also interpret these provisions according to the current and cultural and social reality, and also integrate possible omission. And there is a tendency to carry out innovative and expansive interpretations rather than literal interpretation. But we must differentiate this lawmaking activity to what we call a statute-making activity, because with this, the Constitutional Court is not creating any new law, it's not a legislator, because the Constitutional Court is only making explicit what is already contained in the constitutional provisions. So this is because we do not have a legislative initiative. There is not any procedure that allows for the participation of minorities and majorities, and none of the elements that defines or characterize the legislator, as García Roca and Llorente says. But the Constitutional Court, of course, with this interpretative function, makes constructive interpretation of norms, construct principles, and in this way participates in the establishment of superior rule of law. So just making this previous consideration, I want to focus my presentation on giving some examples of how the Constitutional Court, the Spanish Constitutional Court, carries out this lawmaking activity, this interpretative function at constitutional level and also at sub-constitutional level. At constitutional level, we can find many examples. This is something that is essential for any constitutional test, as we have seen with the examples of the other constitutional courts. And in the case of Spain, this role was essential during the first year of our democracy to defend the Constitution as the supreme normative statute of Spain's legal system against the attempt to just contemplate it as a mere programmatic declaration. And another area that I want to show you where the Constitutional Court has developed this major role is in relation with the construction of the regional state. This is because the Spanish Constitution only establishes the principles and the framework within which the construction of the regional state can be carried out. And this is why later the Constitutional Court has had to interpret many of the provision of Title 8 of the Spanish Constitution. And this happens also in particular with the principle of self-government of the autonomous community. Already in 1991, the Constitutional Court explained that this is a limited power that is not sovereign, and it cannot be opposed to the unity principle enshrined in the Constitution. And more recently, the Spanish Constitutional Court has had to interpret it again to the problem of the sovereignty process in Catalonia. And in 2014, for example, the Constitutional Court has established that this right of self-determination as a right to decide is not recognized in the Constitution, but that is a political aspiration that can be defended within the framework of the Constitution, because there is no room in the case of Spain for a militant democracy. There is not a positive duty to adhere to the Constitution. So if within the framework of the Constitution, respecting the principles that it establishes other ideas, wants to be defended. This is possible, like this political aspiration of Catalonia. This is permitted. If it's done without respecting the constitutional framework, then this would be unconstitutional. Also, in two other cases in 2017, the Spanish Constitutional Court has also had to again interpret this principle of self-government of the autonomous community because of two laws adopted by the parliament in Catalonia in order to carry it out at the referendum, and then to adopt a law for the transition and the founding of the Catalonian Republic. And the Constitutional Court, again, well, in this case, reminded that this self-government principle can never consist in a right of self-determination as a right to foster and accomplish unilateral secession. This right is not recognized in the Constitution, and the Constitutional Court clarifies that this right has not become part of the Spanish legal order because Spain has signed international treaties that may talk about the possible rights of self-determination. Well, this is a very political problem, and the same Constitutional Court has reminded that only the political authorities in the end are the ones that will be able to solve the current conflict that we have in Spain. Another example of how the Constitutional Court carries out this interpretative function at the constitutional level is this case of 2012, and it shows how the Constitutional Court also understands the Constitution as a living tree, as a living constitution, and how the Constitutional Court also takes into account the current social and cultural reality. This was an action of unconstitutionality against a reform of the civil code that allowed the same-sex marriage. And well, the court explained that even though in 1978 that in 1978 when the constituent was talking about the right to marry, it was talking other problems like the possibility of divorce, the rights of the spouses, the equality, but it was not in the mind of the constituent the same-sex marriage. The Constitutional Court also uses here the progressive interpretation, this idea of the Constitution as a living tree, and emphasizes that the Constitutional Court cannot ignore the current reality, and using this technique of progressive interpretation, finally the court understands that the legislator has developed the institution of marriage in accordance with the Spanish legal culture without making it unrecognizable for the image that this Spanish modern society has of the institution, and that the legislator has opted between the different available options allowed by the Spanish Constitution. At sub-constitutional level, the Constitutional Court can also decide over the constitutionality or unconstitutionality of a law and declare it valid or invalid. And like other constitutional courts, we can see how the Spanish Constitutional Court modulates the effects of its rulings because of legal certainty issues. And this is why we can find that not always unconstitutionality is linked with nullity. They are sometimes separated, and both of them separated from the external effects. And here also the Constitutional Court uses the technique of interpretation Through it can modify the content of the legal norms, and the Constitutional Court always try to exercise self-restraint and respect the will of the legislator, or take into account the will of the legislator. And for example, the Constitutional Court can declare the unconstitutionality of a norm or part of a norm, but not declare the nullity in order to avoid not to impede the positive effects or the constitutionality necessary effects that the provision can produce. Sometimes the Constitutional Court also does this because if it declares the nullity, this is going to entail a modification of the law intention. And as I've mentioned, the Constitutional Court always try to respect as maximum the will of the legislator. As an example, I have used this case of 1987 when we have this problem of this law regarding the rights and freedoms of foreigners in Spain. As you can see, this word in Spanish, interesado, it does not have an extra translation into English. This is why I have left it in Spanish, because the problem was the ambiguity of the same word. And the Constitutional Court pointed out that it was clear the will of the legislator to eliminate the previous situation of total governmental availability over the freedom of the aliens pending expulsion. And therefore, the Constitutional Court declared that in conformity with the Constitution, this term should be interpreted or understood as the equivalent to request from the judge for the authorization to extend the interment beyond the 72-hour term period established in the law. So if we examine the constitutional case law at this constitutional level, we can see that it also performs this creative role. It searches for an interpretation in conformity with the Constitution and always examines the will of the legislator whenever it's possible. The court also has emphasizes that this technique of interpretation has limits, and that the use of interpretation is not possible when the inconstitutionality is not going to be eliminated. But in the end, the court always tries to exhaust all the possibilities of interpretation and declares unconstitutionality only when there is no doubt that no interpretation can save this finding of unconstitutionality. As other constitutional court that has been analyzed, we can find these different types of interpretative judgment, also manipulative judgment, as Professor Nausicaa Palazzo has commented with regard of the Italian Constitutional Court. And I think I'm running off of time. My general conclusion after examining the case of the Spanish Constitutional Court is that through this interpretative function, through this creative role, it has exercised a positive task, and it has contributed to the configuration of the Spanish democracy. It has also helped to legally pacify complex conflicts, and it has also been important its judgment for the development of or the centralized model of the state. Thank you very much.
All right, thank you very much as well, and also for again respecting the time limit. It means you have around 8-9 minutes for discussion, and I do not see any questions in the chat. So maybe again I will be the first one to ask a question, and this time I have heard of this instance when the Constitutional Court ruled against the Supreme Court, and then the Supreme Court judges condemned judges of the Constitutional Court in civil liability, and then there was another round of proceedings in front of the Constitutional Court. So something I believe still is imaginable in Germany, and I hope also in Italy. And my question would be, how did the public, but also the executive, reacted to this incident? Was it understood as a sort of quarrel of judges and not interesting beyond the judicial circles, or did it resonate also outside courts?
Regarding the relation between the Constitutional Court and the Supreme Court, there have been some tensions over the years. This is one of the case, the one that you have commented, that magistrates of the Constitutional Court bring an amparo appeal. And obviously for the public, I think this was not one of the most maybe problematic cases, or it does not have such an impact. This particular one. There was another conflict with the Supreme Court when the Constitutional Court annulled the judgment of the Supreme Court and declared as a firm the sentence of the it was, I think, the previous instance, and the compensation that this instance has adopted. It was the Chrysler case regarding the right of honor to this famous person in Spain, instead of returning the case to the Supreme Court, so the Supreme Court can apply the sentence of the Constitutional Court and solve again. Maybe this case reaches more to the public because of the person involved than the other one.
Mm-hmm. Right. So are there, Jan Malíř, my colleague from the Czech Republic, is asking. So he's asking, have there been any attempts to eliminate the effects of the court's case law a posteriori through legislative amendments in Spain, or is it the court's case law always taken as an authority by political branches?
In general, the legislator has a good dialogue with the Constitutional Court and has applied its judgment. But yes, we can find examples where the legislator has not aligned with the Constitutional Court. And there was a case, let me see, I don't know if I can find it. It was related with, it's a little bit problematic for me explaining in English because it has very lots of legal words, criminal words. So maybe for the subsequent intervention, if I can try to find it and comment it. But yes, in that case, the legislator made a reform in conformity with the position of the Supreme Court and not the position of the Constitutional Court. So there have been occasions where we have found this listing.
All right, so then there's a question by Gabor, and it concerns both Italy and Spain. So maybe Nausicaa can also answer it. And it concerns the non-right-wing populism And Gabor asks, what is their relation towards judicial lawmaking by constitutional courts in the respective countries? So maybe starting with you, and then we will activate Nausicaa.
I have not understood the question, sorry.
So in both countries, there are non-right populist parties. And the question is, how do they relate to constitutional courts' activity?
The populist parties,
Yes.
their relation with the Constitutional Court.
And he's asking specifically on non-right populist parties.
Well, I think all the political parties in Spain and currently more right-wing populist parties uses the challenge of unconstitutionality when they want to that a law adopted by Parliament to be annulled when they do not achieve to obtain their objectives in the Parliament. There is a tendency maybe in Spain to bring a challenge of unconstitutionality to the Constitutional Court. And but I think not only this type of parties, also Popular Party and the Socialist Party on certain occasions have used this.
Mm-hmm. And Nausicaa?
Yeah, no, I read in chat that Professor Almais has written, I do not dare to call Cinque Stelle leftist. I wouldn't dare either, because that would make me sick to my stomach. But the Movimento Cinque Stelle hasn't been very interested in the Constitutional Court so far, because the Constitutional Court has not stricken down the most important reforms of the parties as opposed to other reforms by the League party. So it's been it's been a relationship of indifference so far. That's my understanding, because again, the Constitutional Court has not taken an oppositional stance towards their reforms. By contrast, when the President of the Republic did take a stance, which is the second guardian of the Constitution, did take a stance against the reforms, they called for impeachment, which is something that does not even exist in our Constitution, and they've been really vocal against the President of the Republic, which is also a super partes actor. So I think the analogy would stand. So we would be able to argue that should the Constitutional Court run against their interest, there would be that this relationship of indifference would become a relationship of war, a belligerent relationship. Yes, thank you.
Okay, and then there is one last question concerning Spain, and that's the several rulings of the Spanish Constitutional Court on Catalonia independence. And I assume it should read, did it protect, or did it say that it protected the fundamental rights and democracy?
Well, the different rulings protect the constitutional order, because especially with the last two, in 2017, with the two laws adopted by the Catalonian Parliament, the constitutional order was being challenged. The sovereignty that resides in the Spanish people, the unity of the Spanish state, and the constitution as the supreme norm, and also the same what we call Estatutos de Autonomía, statutes of autonomy. This is the main rule within the autonomous community, because these two laws were not respecting this constitutional framework, these statutes of autonomy, and they were trying to breach it in order to do this referendum and become independent on a unilateral way. And as I explained, the Constitutional Court has emphasized that there is not a right to decide as a right for unilateral secession, that the constitution in Spain admits other ideas, other political aspiration, including to want to separate from the Spanish state, but it has to be done within the constitutional framework, respecting the Spanish constitution and the principles and rights of the constitution. So with these judgments of 2017, the Constitutional Court has also tried to do an exercise of self-restraint and has also recovered some of the respect that maybe previously it has lost due to a previous judgment regarding a reform of the Statute of Autonomy in Catalonia. And well, in the end, as I've mentioned, this is a political problem that we have. And when the Constitutional Court has to intervene, it is put into the spot. And even though we have its judgment, in the end, only political actors are going to be able to solve the conflict that we have now.
All right, so that brings us to the end of this part of our workshop, and now we are moving towards two presentations which will concern the impact of judicial lawmaking activity of Western courts in Eastern Europe. And the first is by Lech Karlicki, Professor of Constitutional Law at the University of Warsaw, but of course also a former judge of the Polish Constitutional Tribunal and the European Court of Human Rights. Just to give a note of time, we have now 45 minutes left for the two presentations and the discussion, and I hope that we will have some time for discussion, because it's a unique opportunity to have you and also Gabor in one place, also with all of us here. So please.
Thank you very much. It's a great pleasure to be here, and I'm very grateful to Monika and to other organizers for including me into this meeting. Well, my homework was to prepare something about the impact of the Western constitutional courts on the case law of the Polish court, which is a different topic from those we have already discussed earlier today. Which means I'm not going to talk about two things. First, I'm not going to talk about the present situation in the case law of the Polish Constitutional Court. I must just admit that full comprehension of the new case law exceeds my intellectual capacity. So it would be rather difficult to squeeze it into scholarly framework of our discussion. Then secondly, I will not talk about the very question of lawmaking in the case law of the Polish Constitutional Court. This has been discussed in the book by Professor Czarny and Professor Naleziński. It's not too much to add. Very briefly. Number one. Of course, the Constitutional Court of Poland has been a lawmaking actor and created a lot of different rules on both constitutional level and the statutory level, and it has been done by different techniques of positive, negative legislature and many other mixed decisional techniques. Whether it was legitimate or not, it doesn't matter, but this is the fact. So at least clearly, this court has been an important lawmaker in the Polish reality, not the only one. The role of the constitutional, of the Supreme Court and role of the Supreme Administrative Court for both constitutional lawmaking, maybe not so clearly, but for the statutory lawmaking in a very clear manner, has always been quite relevant. So this is not the problem whether. The problem is rather how. So how this case law of the Polish Constitutional Court related to some external influences in a say, theoretical dimension. I can always say that number one, the appearance and development of the constitutional review in Poland could be regarded as an almost clinical example of a legal transplant of an institution which did not exist before. Successful, unsuccessful, this is another story. And then the use of a comparative argument or comparative research in the case law of the Polish Constitutional Court has always been instrumental. In sense, it could be seen as an example of an applied or pragmatic approach to comparative studies. What was relevant, necessary, was somehow researched elsewhere. But now we, of course, should keep in mind that the Constitutional Court in Poland, on the one hand, emerged in the constitutional void. This was early 1986. The existing Constitution of 1952 has never been regarded as a very, let's say, legal or legally prone to interpretation instrument. So the judicial applicability and the way how constitution should be applied, this was practically a tabula rasa. But constitutional void did not mean intellectual void. And here there was already something in 1986, 1989, when the real transition started. Well, there was some historical tradition of pre-war Poland and its contacts with private or public law of Western countries, where inspirations were, of course, quite clear and quite common. There was a problem of legal education, and that is for my generation. And this was the generation that later determined what was happening in 1980s, 1990s. We mostly were taught by professors who graduated before the Second World War, and if they had training, again, of a real law taught at real universities. So intellectually, they were formed in the Western legal tradition, and we are in Krakow then, so this is not necessary to develop this problem. This even applied to constitutional law. So at least one of the most eminent professors of constitutional law in this time, Stefan Rozmarin, was very highly and very well trained in different aspects of Western legal culture and Western legal doctrine. So this also was seen in the legal research already after 1956, but clearly since 1970s, where Poland became more open to academic contacts with Western countries and Western institutions. And again, this was the privilege for my generation, that practically all of us had an opportunity to spend at least 1 year somewhere in the West. It could be German universities, it could be US universities, but anyway, this was another way how certain quantum of information, culture, values has been internalized by those who later were involved in creation of the Polish Constitutional Court, or generally speaking, Polish transformation. Again, these influences were visible particularly in the doctrine. Again, coming back to Professor Rozmarin, his leading works about the Constitution and particularly statutes of Parliament, this was not very unlike or not very unsimilar to classic Laban's lecture on the relation between Gesetz und Verordnung. And this was more or less a repetition or creative adaptation of this concept to the Polish realities, or maybe not realities, but to the Polish doctrine. There was clear gap between the doctrine and the reality in the communist Poland, but nevertheless the doctrine already existed. And now in 1986, Constitutional Court arrived, something new. Already the drafting process was heavily influenced by Western patterns, a little bit of Germany, a little bit of Austria. Again, this was very visible in what the experts were doing. This was less visible in what politicians were doing. But there was some kind of a new culture created politically under the assumption this court must not be too powerful, so let's give the parliament the power to override its decision, etc. But technically this was left for experts, and those experts again were they had no other alternative than to use Western patterns due to different reasons. France was still not yet sufficiently developed as far as the case law was concerned. Italy and Spain were much more difficult from the language point of view. The United States were too far and too different. Germany and Austria were the obvious points of reference. And then all this somehow connected to the creation of the Constitutional Court. 1986, this is already the end of the communist regime. So there is some room for a more, let's say, independent development on this level. Very characteristic, the Constitutional Court did not want to enter into any of sensitive and hot political problems, like the delegalization of solidarity or something. But it found another place, relatively quiet place from the hot political, from what the generals of the martial law could have in mind, namely the relation between statutes of parliaments and the regulatory acts of the government. And here already in the first decision, the Constitutional Court practically applied the Polish doctrine, Rosmarin, Zakrzewski, and also this classic German concept that a regulatory act of the government must be understood as a very, very narrowly allowed to go beyond what is provided in a statute of parliament. Classic reception. Was it a reception of any case law of the German court or other court? No. This was a reception of doctrine. Was it a direct reception? No. This was a reception of German or Western influences through some Polish doctrine already developed and existing, maybe even established, but the doctrine as such was developed as a result of such influence. And then more or less the same pattern is visible after the real process of transition started in 1989, 1990. The activism of the courts was fueled by the fact that there was no new constitution. There was only new constitutional amendment proclaiming certain principles of the new system. One of these principles was the Rechtsstaat principle. Very easy to guess where did it come from, even if the politicians probably did not realize what they do. But anyway, it was now in the Constitution. Once it was in the Constitution, the Constitutional Court began to use it. It was not possible to address many problems under the Constitution of 1952 because it would make no sense. So the court began to interpret the Rechtsstaat clause in an extremely extensive manner, practically finding in the Rechtsstaat clause all constitutional rules which were not present in the text but were necessary in the practical operation. Again, was the German constitution or constitutional law a source of inspiration? Yes. Was this inspiration articulated or taken directly from the case law of the German Constitutional Court? No, because this was still too complicated. Was it taken from the doctrine? Yes. And if, for example, one have a look into the first formulation of the principle of proportionality in the case law of the Polish Constitutional Court, 1995, this may not be very similar to any language of any judgment of the constitutional of the Bundesverfassungsgericht, but this was almost exactly quotation from the book of Klaus Stern about the German constitutional law. Why not? It is used until today. And there were many other examples and inspirations like that. I'm talking about Germany, but there were also some, of course, other inspirations, maybe less visible, less organized, which, generally speaking, leads me to some more or less general statements. Let me find, I have prepared something very brief on this point. Not very well visible. Okay, I don't know why, but it does not show as it should. So what I was going to say. The Western influence on the Polish Constitutional Court and the case law of the Polish Constitutional Court, I mean institution and case law both, was of an obvious and decisive nature. However, it was mostly in the form of something I would call a Western package. So this was not in the form of direct references to the case law of the German or any other court, even if some references were present. This was rather the form of a more general process of reception or selective reception of different doctrine concepts already existing or translated from the Western systems into the Polish doctrine. So very much it was a process of indirect reception, of a reception somehow of concepts and ideas somehow domesticated already in the writings and on those materials which were the easiest materials to be accessed by the courts and judges and the clerks. Again, open references to Western cases have always been present in the case law of the Constitutional Court, but they never occupied a prominent place. If they were used, again, this was more an instrumental use in this sense that if I wanted to be more convincing or if it was necessary to have some additional legitimization, then why not? But not as an, let's say, obligatory part of an intellectual process. So all those references or impacts were more in a hidden form. Namely, they were not visible in the text. Nevertheless, they existed in the intellectual process of both judges and the clerks preparing cases. Some different approach was to the European courts and its case law. Why? Mostly because the doctrine has never been very strong in creating some theory of the European Convention of Human Rights, or theory of the community or EU law, whereas the case law was probably the most persuasive and most attractive source of information, plus it was binding, unlike the other case. So since at least beginning of this century, references to case law of both Strasbourg Court and the Luxembourg are visible in the in the judgment of the Polish Constitutional Court and were gradually gaining prominence. So again, to conclude, the introduction of judicial review could be considered as a legal transplant, but it was again a domesticated or selective transplant due to this particular situation of Polish transformation and this particular combination of doctrine, Polish doctrine, case law of the courts, and last but not least, by the fact that most judges of the Constitutional Court were also professors of law, so they have this sometimes very unjudicial way of thinking and reasoning. Thank you very much.
Thank you, and we have very little time for discussion, but let's hope there will be some also at the end of the workshop. But please, everybody, do you have any questions to Leszek now? Well, if not, I will take all the time for the discussion and then we move to Gabor. But my question possibly, again, doesn't relate directly to your paper, but where you say the story ends in 2016. And I'm wondering, because you are also a constitutional law professor at the university, so what is the approach of you and your colleagues at present when, in fact, constitutional law can emancipate from the tribunal, because you may, for some reason, think that this tribunal is not really a constitutional tribunal because it was not constitutionally constituted. So how do you approach this sort of schizophrenic position that on the one hand you have an institution which appears like a constitutional tribunal, but according to how you understand the law, it is not. And now you have to teach it to students, you have to somewhat, you know, conceptualize it. So how do you do it, basically? That's my question.
Well, of course, this is, again, as I mentioned in the beginning, intellectually complicated. Having lived for almost more than 3 decades under the communist system, I'm well accustomed to institutions which meant completely different than it might seem on the first sight. But more seriously speaking, the first problem for the Polish doctrine is how to treat the existing constitutional courts. And then they are, generally speaking, 2 types of reaction. The one is an absolutistic reaction. This is no longer a court. This is something which has no legitimacy. It is composed of mostly illegitimate judges. So we should not give too many attention to it. The other position is, let's say, more pragmatic. Okay, it still exists. There is some case law. Oh, in non-political cases, this case law is no bad, frankly speaking, even today. So if, let's say, for a lawyer who is dealing with Verfassungsbeschwerden in Poland, still may be a good idea to send it before a constitutional court. In the political, of course, dimension, this is a completely different thing, and this was already mentioned, mostly a confirmatory court. But this is also important. If we have, let's say, a very important resolution of practically whole composition of the Supreme Court, dealing with how newly appointed judges of ordinary courts should now be assessed. Do they have, are they able to sit and to still ensure equality for a court, to be independent and established by law or not? And the Supreme Court established certain criteria. Now the Constitutional Court decided, no, this is unconstitutional. This is difficult not to notice, even if this is probably completely incorrect. The very last example of abortion is also a similar situation. There is a change in law effectuated by the Constitutional Court. Maybe it was legal, unconstitutional, or whatever, but this is some fact which should be taken into account. Now, the reaction. So what to do? Whether it is or whether it is not a court we should take into account as existing. There is a shift of most of the doctrine towards the regular courts, Supreme Court, particularly Supreme Administrative Court, as far as judicial review is concerned. And whereas most of the Polish scholars before, me included, were of the opinion decision on constitutionality of statutes, at least of unconstitutionality of statutes, should be reserved for the Constitutional Court. The other courts do not have powers to nullify a statute or to refuse application of the statute. Now, the leading position is that as there is no guarantee on the Constitutional Court level, probably it's better to endorse powers of the regular court, the Supreme Court, the Supreme Administrative Court, as courts having a power to review constitutionality and to refuse applicability. But this is not easy under the Polish Constitution. But then there is this other argument, namely, okay, maybe the courts do not have such power as far as constitutional review is concerned. But they clearly have a power to review the conventionality, so compatibility to the European Convention, and also conformity to EU law of a statutory regulation. So maybe, and as fundamental rights are developed in both of these systems, maybe this is the way. Of course, this is all schizophrenic, as you said, and this is not easy. But this is this clash between absolutism and the pragmatism. So how to react to situations which are in the reality and somehow has to decide existing cases and controversies.
Well, thank you, and I'm sure we could continue in this sad discussion for much longer, but we are now left with 20 minutes for Gabor and his considerations on the impact of Western constitutional courts in Hungary. But let's hope there is still some time after Gabor's presentation. So Gabor, please, the floor is yours.
Thank you very much, and thank you for the kind invitation, and it's my pleasure and honor to be here. I try to share my screen because I prepared some slides. Before I start the slides, two disclaimers. One is very similar to what Leszek has already said, that this is not a new and not a comprehensive research what I'm presenting here. I will talk about two periods of the Hungarian Constitutional Court's jurisprudence regarding the impact of Western constitutional courts, and as you see, I will report mostly on German court, on the Bundesverfassung's impact. The other disclaimer is that I cannot be considered as an objective observer, especially not in the first period of the Hungarian Constitutional Court practice, because from the very beginning until '96, I served as an advisor to the that time president of the court, László Sólyom. So certainly my assessment can be very much challenged, and I'm also not very objective regarding the current court. So let me start with the first period, which is practically the so-called Sólyom court period, the very activist constitutional court led by László Sólyom from 1990 to 1999. Here, the use of foreign law was very much an extensive exercise. Similarly to what Leszek has said, it's of course it wasn't a very kind of explicit use of the case law, much more the use of doctrines, sometimes hidden, sometimes not hidden, sometimes domesticated, and sometimes even with certain deviations. I will come back to this. So this Shoyam court can be characterized as using Western ideas, not necessarily on a global scale, certainly on a German scale. This is the conclusion of Catherine Dupre's very interesting book published on the experiences of the Hungarian Constitutional Court, importing the concept of human dignity, mostly from the German concept. And here, similar to Poland, the reasons of this kind of import from Germany or from other Western legal systems can be explained by very personal reasons, namely that both the judges and the advisors, like myself, were educated or very much tied to Western legal systems, especially to the German. 5 out of the first 10 judges were former fellows of the Alexander von Humboldt Foundation, which means that they spent several years in Germany, including myself. So this very much can be demonstrated on the concept of human dignity, as Catherine Dupre's book, excellent book, actually proves. So the court started to use a very famous concept of human dignity and general personality rights. It was Ruth Weber's presentation, which talked about the census decision of the German Bundesverfassungsgericht. It was one of the first decisions the Hungarian court referred to in a decision somehow carving out the general personality rights, which is not enshrined in the 1989 Hungarian constitution, and using as a basic reasoning for several decisions listed here. The second issue was a very somehow autonomous interpretation of the German doctrine of human dignity, together with the right to life, in the very famous decision on the abolishment of the death penalty. You may know that the Hungarian court was the first in the world abolishing death penalty, followed by the South African and other courts. Then the individual and the human autonomy concept used in 2 abortion decisions is also a kind of domesticated application of the German doctrine. The outcome of the Hungarian abortion decision is very different from the German one. So therefore, the use of the doctrine is again can be understood as a kind of deviation from the German doctrine, but still the reference has been made to the German doctrine. I'm not talking about the period between 1999 and 2010, when the current government led by Viktor Orban came to power, and actually immediately after coming to power packed the Constitutional Court. So I'm using some data actually provided by the research of Professor Zoltán Center for this period between 1999 and 2008, so almost until the Orban government. So Zoltán Center counted altogether 73 cases out of the more than 700. So about 10% of the cases reference to either foreign court or European transnational courts, Strasbourg or Luxembourg. But you see down there that most of the references are to the Strasbourg, or in a smaller amount after the accession, of course, to the Luxembourg court. And here you see the very few references made to the German Constitutional Court, altogether 12 references within this 10 years. So actually, the use of Western constitutional courts practice practically disappeared after this very activist use by the Shoyom court. Let me turn to this second part of second period of my presentation, and this is a jump to the court which I may characterize as a non-independent packed court loyal to the government, and this is the current constitutional court. And here, interestingly enough, the court starts to use certain foreign law, again overwhelmingly referring to the German Constitutional Court's jurisprudence in a very famous case decided in 2016 after the European Union's Council decision on the relocation of migrants, refugees. And this is actually this re-emerged use of foreign case law. In my opinion, again, I may not be, or should, I'm not an objective observer here. This is a kind of pretext to send a message to the European Union that Hungary is not only an independent member state, but has a very strong constitutional identity. And this constitutional identity does not allow for the Hungarian state altogether to accept this kind of relocation. So here the court misuses a lot of decisions, mostly by the German Constitutional Court, sometimes referring to the Corte Constitucional and also to the Tribunal Constitucional, the Spanish one. Case law, I'm come back to the concrete cases. The main characteristic of those of that decision, that it's certainly not a European friendly decision, and as opposed to the German doctrine of the Solange decision, two Solange decisions, namely to increase the level of the protection provided by the EU law in the domestic practice. This is the opposite, lowering the level of protection, especially for those refugees who would like to enjoy the advantages of the relocation. So here are certain references. I do not go into the details on those references. In this very decision, I mentioned the number 22 in 2016. First, the court refers to a case of the German Constitutional Court, the so-called Kloppenberg judgment, arguing that the extent of primacy is always determined by the member state's national enforcement. In other words, they argue for a kind of limited primacy of the EU law and no primacy in this special case of the relocation plan. The second issue in the judgment, again, is the limitation of sovereignty to the cases if the EU law is in compliance with the national constitution. In other words, this is the concept of the primacy of the national constitutional order. Reference is made here to a Spanish court decision. And finally, a third type of reference made again to the German Constitutional Court practice is about the constitutional dialogue regarding constitutional identity issues. Heavy reference to Article 4.2 of the European Treaty, of course. So let me conclude here regarding this particular decision, which again is a very unique decision. By the way, beyond this decision, I tried to search the Hungarian Constitutional Court website, looking for other references, of either other German or other Italian or Spanish decisions. For instance, I put two keywords into the search, Tarico in the case of the Italian court, and Meloni, whether I found any reference, and I did not. So this is, of course, not a totally convincing scientific proof, but some indication that this kind of references I'm talking about here are rather a pretext for certain political message. So, but otherwise, if you look at the decision itself, it's very much the same as the German practice of constitutional identity. The court is using the three different types of review here, using the identity review, again, with references, using the fundamental rights review, and using the ultra vires review, arguing that the European Union has no competence whatsoever to relocate refugees against the will of the national parliament, in the case of Hungary, against the will of the Hungarian parliament. And very interestingly, it comes back to the human dignity argument, because the main argument of the Hungarian court is that this entire decision is based on the protection of the human dignity of the Hungarian citizens, not the refugees. The Hungarian citizens' human dignity should be protected against those possible refugees. By the way, the relocation plan in 2015 have foreseen to relocate 1,293 refugees to a country with about 10 million inhabitants. So this was my very short and certainly not comprehensive report on the Hungarian case. Thank you very much.
Oh, thank you, Gabor. And I'm afraid we are getting to the end of the workshop, but I also hope that there will be some questions to you. Oh, Ruth. So it's about the possible misuse of the German decision, Vice decision in Poland and Hungary. So what do you think are the consequences of the decision for the Polish and Hungarian constitutional courts? So in particular in Hungary, how did the German decision of last May resonated?
Should I start to answer?
Yes, please.
Yeah, there have been no constitutional court decision on the case, but the Hungarian government very quickly reacted to the decision, welcoming, not surprisingly, the decision of the Bundesverfassungsgericht and arguing with the same argument as the Hungarian Constitutional Court in this mentioned decision, with constitutional identity, with sovereignty within the member states, and with Article 4.2 of the treaty, saying that this is a proof that even so highly respected constitutional court as the German Constitutional Court does the same.
Mm-hmm. And Leszek, do you have something to add to this?
More or less the same reaction. It has been used by the politicians. Should they be a case, it clearly will be used by the Constitutional Court. So for me, this is just an example of a situation where a judgment which probably was, say, well fitting to what was necessary in Germany, somehow was adopted without full consideration what kind of damage it could create elsewhere. We have to keep in mind that this PSSP judgment is very impressive, but in the very end, the German Constitutional Court ruled, oh well, but if the ECB convinced the German government that everything is okay, let's do it. So more or less it was a declaration. But this declaration, important, I mean, for the dialogue between two courts, could be quite damaging in the context of Poland also. But it's difficult to require from the German court to take such arguments in full consideration.
All right, so thank you, Leszek, and also thank you, Gabor, for your presentation. Oh, there is one more question, the very last one, I think. Which deterrents should be applied to prevent the abuse of power of constitutional courts? And should we elaborate in an effective procedure of some control over the courts? I guess that's a question for a whole seminar, but maybe Gabor may try to answer it, or both of you at the very end of the session.
There are two possible answers to this question. One answer is that maybe the European institutions should try to influence those member states which do not comply with the values of constitutionalism. In the last 10 years, it has been proved that this was not really effective. The other possibility lies in the national circumstances. So maybe in more happy times of the history of those countries, there can be again constitutional courts which really play the role of guardians of the constitution. Maybe it will be too activist, as it was the case probably in Hungary in the 90s, but I wish to have an activist court which protects fundamental rights and other values.
All right, thank you. And Leszek?
First of all, no constitutional court is able to withstand political pressure if those who exercise this pressure are not ready to observe constitutional rules of the game. This is the old question about Pope posed by Comrade Stalin: how many armored divisions does have the Pope? How many armored divisions has a constitutional court? Deterrence. There is another problem. In both countries, in Poland and Hungary, this present constellation has been confirmed in democratic elections. I'm not, I have no competence to assess a Hungarian election, but Polish elections in 2019 to the parliament has not been challenged. So this is the will of the people. Does it mean that the people is stupid and the court is wise? This is an attractive position, but not very strongly supported by the general theory of democracy, etc. So the courts, of course, should have some more power. There should be some more technical or institutional arrangement, not allowing to do something or requiring to do something the other branches of government. But this all would not function if the other branches of government decided that the constitution is not particularly important, and whatever we do, this will be done.
All right, thank you very much for this. Now, I have been told by Monika that there is one more question by Professor Zirk Sadowski. We are over time, and because this is...
It will be very, very short.
All right.
Because it's not a substantive question. I would like to express my gratitude to Professor Karlicki, because I think that especially for you is important, but I can assure you that this description of our situation in state of minds is perfect. It was perfect in this lecture. I treated it like a kind of medicine, because introduce the order. So result is very simple. We are very worried not about courts and judges, but about our sovereign. It means people, you know, because after 30 years, we discover suddenly how well weak are values which we are rooted in this society, which we support, that are present and are everyday values. We need a whole new work about this problem. Well, it's very difficult to introduce, to translate values without historical process. Yes, books are not enough, and even especially in the time of crisis of authorities. So I think we have to work, because this election is the most important moment now. So thank you very much.
Well, thank you to you. And I suppose now we should end. And perhaps I should ask, or Gabor has something very quick. Yeah, Gabor.
Yeah, one sentence, and only talking about Hungary. So before we blame the people, I would say the Hungarian election, the last two elections were free but not fair elections. And there is no free media in Hungary. So it's very easy to convince people about the importance or the non-importance of constitutions, the importance or non-importance of the EU. So do not only blame the people for that. Blame the autocrats first, and then we'll see.
Okay, okay. Well, thank you for that. And I suppose that Monika should close the very conference. So I would just now leave it to her, but also wanted to thank to all of you who participated actively or also as listeners. And I look forward to meeting some of you at some other occasion.
Only one word, excuse me, because I would like to underline that I'm not blaming our people if in this context of Hungarian, but we are worried. It's a basic difference because it's lack of means to change minds because of this problem which you underline as a lack of good mass media and so on and so on. Thank you. Excuse me.
Thank you very much. I'm not going to formulate a conclusion. I think that the general conclusion is obvious and not surprising that European Constitutional Court strongly and diversely also influence the national legal orders and co-shape the law together with the traditional legislator. But I'd like to say that our research focused mainly on identifying these different ways in which constitutional courts and new elements to the national legal orders and comparing the practice of constitutional courts in this regard. And I think that we are all aware that the topic is worth undertaking further research, firstly, and secondly, that this concept of judicial lawmaking as it relates to constitutional courts still needs theoretical conceptualization and elaboration. So at the very end of our meeting, I would like to thank Frusina and Jan for the smoothing running of the panels. Thank you also to the speakers for the interesting and inspiring papers, and all of you for joining the webinar and participating in the discussion. I would like to thank very much our distinguished guests, Professor Garlicki and Professor Halmai, for the excellent presentation, which brought to our discussion new topics. And in a special way, however, I'd like to thank all the authors of the book for their contributions and for their confidence in me as the editor of the book. Working with you has been a real pleasure for me, and I hope that we will continue our cooperation in the future. So once again, I would like to thank for your participation in today's seminar, and see you again, maybe in Krakow or somewhere else.
Thank you.
Thank you, and bye-bye.
Thank you.